Okay, welcome to week one, or rather week two actually, already week two. Last week we had the open house, and so tonight we're going to go about an hour and a half to try to cover as much as we can. I know a lot of students are probably watching the president's speech. I was watching it also, that's why I got a little late start, but I set it to record, so I'll get a chance to watch it afterwards. So I'm kind of caught in between that. Let's see, 8 years ago, around November, actually, I was in the park and actually had a ticket. This time I didn't try to get a ticket because I had to teach class and there were a number of other things. So decided I'd just watch on TV. So anyway, so let's go ahead and let's just get started. I'm going to start out by sharing my screen, quickly going over the assignments for the week. Okay, and we're going to start with the week two announcement, constitutional issues and elements of crime. Chapters 3 and 4 of criminal law and procedure are your reading assignments. Make sure you review the activity, the Constitution and elements of crimes. Briefly, I'm going to cover that one. And then make sure that your discussion posts, our initial discussion posts, are in tonight by 11:59 p.m. Central Standard Time, strict liability crimes. Many of you have posted them, and I've responded to a few of them already. And then Saturday, you post your reply post by 11:59 p.m. relating to strict liability crimes. And you're required to only reply to one discussion post, but I recommend replying to as many as you can. And don't just, briefly say, I like your post, and blah. Elaborate on it. Make it conversational and informational as well, because it actually helps your classmates at the same time, helps you guys to get to know each other, help me to get to know you and see some of the things that you've discovered from your reading and research relating to the topics for the week. Finally, there's a written assignment this week, cruel and unusual punishment. You will have me, I'll go over that in a minute. And then there is the quiz. The quiz, I highly recommend taking it near the end of the week after you've gone over all of the materials. And then finally, my motto at the end, adversity is a springboard to success. I shared with you guys last week what that meant to me, so I won't go over that again, but be aware that I am serious about it. Some of you already have had adversity. I've already gotten some emails from people, and I work with you. So anyway, so let's get right into looking at the calendar. Let's go quickly and look at the course calendar, which again gives you a shot what your reading assignment was that I just covered a few minutes ago. Your initial posts are due tonight. Your reply posts Saturday the 14th, and then your written assignment is due on Sunday night, 11:59 p.m. Central Standard Time, and the quiz as well. Okay, so let's take a look at and elaborate on what that is. I always highly recommend that you pay close attention to the course calendar. It gives you a lot of information. So in Module 2, these are the assignments again, your written assignment, and it gives some facts and regarding the 8th Amendment, and it's a 2 to 3 page paper. Now, be sure that you take a good look at the rubric that I gave you on written assignments. It tells you how you will gain your 20 points. It'll tell you how you can lose points as well. In addition, I indicated that if you don't do any research, that you will lose 2 points. That is not in the rubric. However, that is on the course homepage, and it's at the top of the syllabus. The key idea is for you to conduct research in every written assignment, okay? And so 2 to 3 pages, APA citations in the body of the paper and references at the end. Not, and you know, some students have put one citation in there and just thrown it in there. I can tell. No, you want to write a cogent paper with details and information using your critical thinking, making sure that you've run it through Grammarly so that you can make sure that it doesn't appear as if most of your paper is from sources that you discovered through your research and that you had very little critical thinking. The key essence of written assignments is critical thinking. Of course, you conduct research first. You give credit to the sources that you include in your paper and citations in the body, and then listing your references according to the APA format. And there's plenty of information, if you don't know about the APA format, under the Resources tab. So if you go to that, you will be able to see that. I kind of alluded to that last week. So then, of course, your discussion posts, and you already know about that, about strict liability crimes, okay? And then, of course, your quiz. And that's your assignments for the week. You do not have a project. Matter of fact, you will, let's see, I think you'll have a project next week, and then after that, then you won't have one until, I think, week 8. I think the last 4 weeks of the quarter, then you'll just have the written assignments. So it behooves you to keep up and get it done. All right, so now let's take a look at the lesson content. Our objective is to discuss the constitutional issues, list the elements of crimes, and describe how crimes are classified. And then again, here's a repeating of your assignments for the week. And then these are the sections that I told you to take a look at. I'm not going to go over them, but these definitions are very, very, very important to understand in terms of your written assignments and how the law applies, okay, as well. So you want to make sure that you do this. So you want to make sure that you go over these. And I've already kind of shown you before in last week how these things operate. A retroactive law that criminalizes an action that was legal at the time it was performed, or increases punishment for a criminal act after it was committed. What do we call that? What do we call that? Can you tell me? Can you tell me which of these up here it applies to? You can type in the answer and then I'll see it. A lot of times students don't want to do it because they're afraid to make a mistake. That's okay. Better to make the mistake here in class so you can get it. But it's always a good idea to try. All the time I've been a student, I've always tried to come up with the answer, and I've been wrong. But guess what? I finally did learn the right thing. When it came in handy, I really knew. Want to take a shot at it? There it is. It's ex post facto law. Accessories after the fact. Nope. It's an accessories after the fact involves let's see, of these governmental power persons who voluntarily unite, mind of a person in governmental power, persons who with knowledge that a crime has been committed. That's that. That's accessories after the fact. Person who, with knowledge that a crime has been committed, conceal or protect the offender. Do one more, and then I'm going to move on. Governmental powers, not explicitly stated in that the government's constitution, but fairly implied by it. What do you call them? There's a key word. Which one is it? There we go. Excellent. You'll find a lot of times that happens. Persons who voluntarily unite with others in the commission of an offense. These are accessories before the, or rather, not accessories. This is an accomplice. That's what that is. The state of mind to do something prohibited by law without necessarily intending to accomplish the harm which results from the illegal act. The state of mind. Which one? Got it. Very good. Parties whose conduct involved direct participation in the crime. You say specific. Try this one. The principles. Nope, the principles. Persons whose conduct involved direct participation. Governmental power explicitly granted by that government's constitution. There we go. Now you're getting it. And then the mental purpose to accomplish a particular thing prohibited by law, such as the death of another person. It's only two left. Yep. And then, of course, the last one. So these little exercises help you. And then if you get the wrong one, it pops back up. So that helps you in terms of doing it. So now I'm giving you all the assignments. So now I'm going to get right into the lecture and going to spend the next hour and roughly 15 minutes talking about these items. So you should have received these PowerPoints. I sent them to you Sunday night. Every week you will get them. So make sure that you save them. And then also you can take notes along with what you are going to hear here as well. I also sent you some additional information that goes with each chapter, kind of an outline of the chapter. That's for your information. So our first chapter is about constitutional limitations on the prohibition of criminal conduct. And I'm going to go through these as quickly as I can. All right. So what is judicial review? Basically, the law is what the courts interpret it. It is, our system is divided into three sections of government. You got the executive branch, which is generally headed by the president, and the federal level, the governor and the state. And then, the law enforcement and police fall up under that. Then you have the legislative branch, which consists of the House and the Senate in federal government and in many jurisdictional states as well. And so each of those, and then the final department are the courts. And they start out oftentimes with trial courts, the circuit court of whatever, or the court of whatever it is, jurisdictionally. And that's where your trials originated. And then they go to what they call the appellate court. The appellate court is the first place that you can appeal a decision. And then ultimately the final place is the Supreme Court. The highest court in the land is the United States Supreme Court. And what the United States Supreme Court does is that they interpret and say what the law is. Since 1803, the case of Marbury, not Marburg, the courts have said in a famous case that it is the courts who interpret the law. It is the courts who decide how to apply the statutes. and how the law applies. And then we deal with the issue of unconstitutional per se, which means on its face, it's unconstitutional. For example, to discriminate against a person on the basis of race, religion, sex, or national origin, a law that comes up is unconstitutional on its face because it actually violates the U.S. Constitution, equal protection, equal rights of people. And then it could be applied in an unconstitutional fashion, such as though the law, for example, that says that there should be no discrimination, but it appears that there's a pattern in which you're hiring and firing people, or that you're arresting people based that the numbers are despairingly high in one ethnic group, race, national origin, or so forth and so on. And so it becomes unconstitutional as applied, and the courts will review that. The legislature, as I said, enacts the laws, and so I've already talked about that, so I won't go over that too much. Congress, though, you should be aware of, does not handle the law in the state. They only have authority over the District of Columbia and the federal territories or federal laws. And the enumerated powers of Congress are laid out in the Constitution. And there are certain implied powers that go with that as well. They have the right to pass laws. For example, the Patriot Act, the Wiretapping Act, the Fair Credit Reporting Act, the White Slave Act, which has nothing to do with slavery. It has to do with taking a person across state lines for sexual purposes, is enacted under Article 1, Section 8, the Commerce Clause, and it is a power that is given to the federal government to be involved in the law. For example, prostitution is generally controlled by the state law. However, though, if you cross state lines, as I said before, then the feds get involved. Of course, if you, like, for example, rob a bank, then we're talking about you getting into the federal. You rob a train, a truck. Now, lately, I've seen some really, really, really wild things happen that we hadn't seen in a long time. People are now robbing postal workers. That is highly unusual. FedEx, UPS, delivery workers. Then you get into the federal sphere where the federal government comes in the form of the FBI. Okay. The Commerce Clause, as I already said, controls economic activity among the states, affecting more than one state. Congress has relied on the Commerce Clause to enact laws, as I said a few minutes ago. And I already talked about this point. Congress has broad authority to enact laws by stretching the concept of interstate commerce. If you, for example, use the phone, the internet, the mails, if you send somebody a text message or something like that, now you're getting into interstate commerce because of the fact that, and here's the deal, some people don't get it. Let's say, for example, you make a phone call to somebody who lives right in the same town that you're in. And the question is that involving interstate commerce? The answer is yes, it is, because the vehicle that you're using, because here's what happens with a phone call. You make a phone call. It doesn't go directly to that person. It goes to outer space a lot of times now, since we've got the satellites now, and, you know, you got cell phones, you got people have wireless phones, and then the whole system is hooked up across the United States, and then it'll come back to the local area there. So you can involve yourself in a violation of a federal law. Treason is not a big deal. We don't run across it a whole lot. In betrayal of the country used to be a very serious offense, punishable by death. However, though, treason has been abused in recent times. In the McCarthy era, which was in the 50s, where a person was considered to be a communist if they did something or said something against the government, that you have a right to express your position as an individual under the First Amendment. However, the point of the matter is that it was considered as treasonous if you went against the government. And so because of that, treason has been pushed back, because you can't punish someone you don't agree with. The United States Constitution sought to limit the power of the government to use treason as a tool to punish political dissenters. A person can only be punished for treason if they acted to levy war against the United States or in adhering to enemies of the United States. So there are a whole lot of questions that are involved here with what is treason. I would say that the young man, Edward Snowden, who left the United States because he was selling or even giving information to our enemies, that would be considered as treasonous. However, though, what has happened is that he can't be reached because he's in the country where the United States, the country won't send him back because you could possibly be subjected to life imprisonment and or the death penalty. Two laws that don't exist, but this is for historical purposes. One's called the Bill of Attainder. This is a act imposing punishment where there's no trial. We don't have that anymore because our Constitution gives you the right to due process. In other words, the right to face your accusers and to gather evidence so that you can respond and provide a defense. Ex post facto, we talked about that a few minutes ago. A law passed after the act. For example, it means what it says, ex post. It means after the fact law, ex post facto law, a law after the fact. So let's say you do something and then they pass a law that says that what you did becomes illegal. Well, they can't prosecute you for what was done before the law took place, or a modification of the law that makes it possible for something that you did. I'll show you in a few minutes. But both of these are prohibited by the United States Constitution according to these old cases, going back to 1946 and 1798. Here's an example here of an ex post facto law, where the Supreme Court reversed the conviction of Scott Carmel for sexual assault of his stepdaughter. Now, what he did was, at the time, Texas had a law that said that a defendant could not be convicted merely based on the testimony of the victim, unless she was under 14. Well, Carmel had been convicted under an amendment. So the amendment was ruled ex post facto. Therefore, the amendment could not, and that's why the Supreme Court will reverse the decision. The key factor is the law, is the act legal at the time you commit it, and then it becomes illegal. Then in that case, they try to prosecute you on it, your defense is an ex post facto law. Bill of Rights of the Constitution, the first 10 amendments of the Constitution, these are a few. The most popular one, First Amendment, freedom of religion, speech, press, and assembly. Now, we're going to talk about some of these a little bit. The Second Amendment, it's a hot topic, the right to bear and keep arms. It is one of the most highly debated issues. And I teach a class on constitutional law, and I have one lecture that's completely on the Second Amendment, and where I go into the details of the history of the Second Amendment and so forth and so on. But it is a hot topic. It involves gun control and battles between people who are anti-guns and then organizations like the National Rifle Association. The Fifth Amendment, the right against self-incrimination. A person doesn't have to testify against themselves. It actually applies when we get into the Miranda issues. The Eighth Amendment says that punishment should not be cruel and unusual. In other words, we should not punish a person in an inhumane fashion. Now, listen to me good. Even if the act that they commit is inhumane, we still, under our Constitution, says we can't. For example, if a person rapes a person, in some countries, I don't know if France still did it, but I know at one time that you'd have, you know, a little castration taking place there. If you stole, they'd cut the hand off that stole, and so forth and so on, those kinds of things. We won't do that in this country because it violates cruel and unusual punishment. There is a debate that's ongoing about the death penalty. Is it cruel and unusual punishment? And the answer so far is no. There's a case called Furman, F-U-R-M-A-N versus Georgia, which the famous death penalty case that came out in 1972 that sets out guidelines for the death penalty. However, the death penalty has been eliminated in many jurisdictions, including Illinois. The reason why it was eliminated in Illinois was because it was determined based on the introduction of DNA evidence and other technological forms of information that's used to exonerate people, that there were people who were actually on death row who did not commit the offense. And so the deal is that if we have one individual who is a possible innocent person, and then they're executed, then what are you going to do? You can't do anything. You can't bring them back to life. The point of the matter is that some jurisdictions, including Illinois, has simply said enough is enough. We do not have the death penalty. And then the Ninth Amendment are rights that are retained by the people to vote, to do many other things too, okay? The Bill of Rights and the federal laws. Now, the Bill of Rights originally applied in the federal, but in 1868, the 14th Amendment, which came about, providing justification for extending the Bill of Rights to apply to the states. And the Due Process Clause, incorporation for procedural protections, hearings, and things like that, came after that. So now the 14th Amendment applies not just to the federal laws, but it also applies to state laws. Cantwell, this is a case in which a couple or family of Jehovah's Witnesses were distributing their material. Well, there was a law in Connecticut at that time that prohibited door-to-door solicitation for any religious or charitable cause without approval of the state. Well, they were arrested for stopping people. They were convicted for failure to obtain approval of the state. The court says no. They try to use this as interfering with people breaching peace, but they said no. This reeks of trying to tamper with someone's First Amendment right to religion, and the court found this breach of peace to be a violation of the First Amendment. Famous case. The First Amendment, though, back to it again, says we have freedom of speech and press. However, you should be well aware that not all speech is protected, such as lewd, obscene, libelous, profane, insulting, or fighting speech. We don't want to provoke people in their face. You can express a position that people might not like to hear, but if you're in a person's face and you're pointing directly at them, or you are in their vicinity and you do it, then you can create a probable issue of disturbing the peace, or you could be charged with fight speech. Clear and present danger doctrine, which means your speech, if your statement presents a clear and present danger, let's say you're trying to get people to stampede, yelling fire in a crowded theater, for example. That's free speech, but it's not protected because you can cause people to be killed or injured. Imminent lawless action, intending to speech to create violence, provoke violence. Now, in this case, this is a Schenck case, historically one of the cases that we study all the time. And when I was in college even, I got my degree in political science, and then in law school, which the Supreme Court upheld this person Shank's conviction, saying that the First Amendment does not protect speech that creates a clear and present danger. Now, what Shank did, though, was he had mailed 15,000 leaflets attacking American participation in the First World War. Now, be aware of this, that back in 1919, when he said those things, there was a war going on, and that the information that was going out was directly aimed at and adversely affected the morale of the military. Now, of course, as in our times today, Shank would not apply as much because people are able to protest all the wars. Every war I've known, the Vietnam War, the Gulf War, the Iraq, the Iran War, all of the wars have been protested. But the key thing was there was a clear and present danger. And who was the clear and present danger to? The troops. In Hess versus Indiana, the United States Supreme Court reversed the conviction of this man because the speech he gave did not constitute imminent lawless action. He was convicted for yelling, "We'll take the effing road street later," during an anti-war demonstration. He just yelled it out. Okay, so he wasn't talking to any individual. He was just expressing his position. So the court said that his speech was not directed towards a certain group or individuals. Therefore, he did not give what would constitute imminent lawless action. Now, somebody might say, well, that might create it. But the key idea is that his speech alone in itself was him venting or sounding off. And that would be permissible. But there's a thin line there, though. Symbolic speech. We are allowed to express our positions on the First Amendment by symbols and conduct. For example, freedom of expression, broad concept invading speech, publication, performances, demonstrations. In other words, you can put together a play or something. You can write a book. You can do things expressing that you are not happy. Symbolic speech includes symbols. For example, the right hand in the 60s was power to the people. That was a form of speech that involved satisfaction or dissatisfaction with the administration or either with the government. Flag burning. Now, the burning of the American flag is protected. You can burn an American flag all you want as long as it's your American flag. And so the point of the matter is that this person was burning American flag, and they tried to arrest him because they said anti-American. Well, it might be considered as anti-American, but that's that person's right as long as it was their flag and not somebody else's property. Freedom of expression versus maintenance of public order. A public speech that threatens the public peace or order can be punished. Cantwell versus we already talked about that. If there are fighting words involved, then we get to that point there. Hate speech. Hate speech, I mean, that is obscenity, profanity, expressing, for example, that you are doing something to encourage someone to commit violence against a person for their race, sex, national origin, or either their religious beliefs, those kinds of things. Obscenity and profanity, getting to the point of disturbing the peace. And then we have to maintain public order. You can fire people up, which is why I always tell my police officers, law enforcement officers, and I teach a class on communications, don't use profanity when you're dealing with someone. Please don't, because your job is to be a professional and not to incite or cause an individual to escalate. Okay, they might be what you say they are, but you're the professional, and you're not supposed to stoop to that level. Texas versus Johnson's example of the flag burning. Now listen to this one. The United States Supreme Court reversed the conviction of Gregory Gregory had burned his flag, and I remember this one extremely well, outside the Republican National Convention in 1984. The court argued that he was not convicted for flag burning, but rather the message he was conveying. So his message that went along with the flag burning is what was protected. Therefore, flag burning could not be used. So you can argue, says, oh yeah, what he said is okay, but when he lit that flag, no. It's protected because it's symbolic in terms of expressing it. And again, remember I said it has to be your own flag or somebody's flag that gave you the right to do that. Virginia versus Black, a 2003 case in which this person was a Klan member, in which the court held that states may punish individuals for burning a cross because you're intending to intimidate a person based on their race, religion, sex, national origin. This Klan member burned a cross during a rally nearby a highway with intent to intimidate people. And as a result of that, that is not protectable under the U.S. Constitution. Free exercise of the First Amendment. You have a right to peacefully assemble in public places. The government, of course, can issue permits for you to have rallies and marches and things like that. For example, we're in Illinois here. I remember some years ago that the Nazi Party wanted to march up in an area called Skokie, and I think the Klan also wanted to march. But at any rate, what they did was they were able to exercise their right to march, but they had to get permits. The government provided protection. Even though we already know what they were doing, they could peacefully march. And when they marched, they were able to go into those communities and areas because it's a First Amendment right. The key thing is that do we want to stop people that we don't agree with from marching? Because if we do reach that point, then we can soon stop people indiscriminately, and we don't want to get to that point. Religion, the freedom of religion. Now, if there is, you can do almost anything in religion. You can do almost anything, and we're going to talk about some limitations for a reason, except the government can prohibit practices that threaten public health and safety. An example is the Tennessee Supreme Court upheld the validity of a statute making the crime to handle poisonous snakes. Well, that's because it's a threat to the public and so forth and so on. It's a threat to the people that appear there. Also, if you are of a religious belief that allows medical treatment to be refused, you can do that, but you can't do that for your children, only for yourself as an adult. Here's an example where the United States Supreme Court upheld a right to peacefully assemble in a public forum. The United States Supreme Court reversed the breach of peace conviction of 187 African-American college students who participated in peaceful, and so here's what happened is that they were convicted, but in reality, all they were doing was expressing their position. They were orderly and so forth, but the fact of the matter is that the law will not allow you to interfere with the peaceful assembly, as I said earlier about the Klan and the Nazi Party. This is something that really is kind of like, I mean, it doesn't really matter much now. This Yoder case, the Supreme Court ruled that compulsory school attendance as applied to the Amish was in violation of free exercise clause. What happened is that the state of Wisconsin had a law that required that the Amish send their kids to the public schools. And the beliefs that they had were they wanted to just be left alone. They could teach their own kids at home. Well, the court said no, because now what you're really doing is you're interfering with their religious beliefs. Now, that course has fallen by the wayside because homeschooling is a regular routine now, and that it's a right that everybody has now. The key here is that if you are aiming at a constitutional right by a law and adversely affecting or hampering that right, it's going to fall on its face unless there's some dangers to the public. Now, here's one. The famous, we call it the peyote case. The United States Supreme Court rejected the claim that the ritualistic use of peyote was protected as the free exercise of religion. And what it was is that these Native Americans were using this hallucinogen in their sacramental ceremonies. Well, the court said that the religious beliefs do not excuse people from complying with neutral laws that everybody else has to obey. It's interesting, there is a church in Indiana, and it's called the Cannabis Church. You can look it up, and you will see that it exists. It is a church in a state where cannabis or marijuana is not legal. However, they have an actual charter that was issued by the state, and they use cannabis in their worship service. Now, here's the deal, though, that when you leave there, if you're under the influence, you can be arrested because of the fact that you're no different from anyone else. Of course, though, you do know, well, here's the deal. You do know what's happening is that many jurisdictions are legalizing marijuana as we speak, and it's a matter of time before even that state does it. But here's my point. If you are driving under the influence, you're still going to be held accountable under the laws for that, because even if the item is legal, drinking alcohol is legal, but you can be prosecuted for operating a vehicle under the influence. So it's the danger to the public aspect of it. And what some people might try to do in this cannabis case is, oh, but we were just simply getting high in the name of our religious beliefs, and that's it. But it's called the Cannabis Church of Indiana. Check it out. You can Google it, and you'll see it. Here's one. The Church of Lukma Babaluaye versus the city of Hialeah. And what happened here is the Supreme Court upheld the right of the church to make animal sacrifices. See, so as animal sacrifices is part of religious ceremonies. Now, the city had an ordinance that said to unnecessarily kill, torment, torture, or mutilate an animal in a public or private ritual or ceremony, not for the primary purpose of food consumption, violates the law. The court said this ordinance is unconstitutional because it violates the right practice religion. Now, animal rights people might not like it, but the courts in a case like this would probably go along with this because there's something that I know. I'm a pastor of a church, and I know what directly is involved here with this. And I always ask my students, do you have any idea about why the court, if you read that decision, really didn't want to deal with animal sacrifices as far as religion, even though some people might think it's cruel to the animals? Do either of you, Teresa or Eric, have any idea about why they didn't want to touch that? Any ideas? You want to type in? Yep. You could do that publicly. Make sure that you type in publicly, because I see you typed in privately. I know you didn't mean it because you didn't want anybody to know, but the answer is correct. Teresa says, because of the biblical sacrifices. That is absolutely correct. The Old Testament, in Old Testament times, the animal sacrifices were offered, and that goes all the way throughout the Old Testament, And some churches still practice the Old Testament. And so that's an attempt upon a biblical belief. And there were animals that were sacrificed, quails, sheep, lamb, all kinds of animals. So the answer is yes, that absolutely is the reason why. Because that would be directly falling in the face of somebody's biblical belief. Absolutely. Good call. Good call. Okay. Let's go back. Now, the Second Amendment, I'm not going to spend a lot of time on it. The Second Amendment, there is a whole big conflict with gun control. Many states have wide latitude. State and local gun laws. Opponents claim these laws violate the Second Amendment because the right to bear arms issue and the whole argument about the intention of the Second Amendment in the first place, which is highly debated. However, be aware of the fact that there are people who are into gun control, and then there are people who are anti-gun control because they said it adversely affects a Second Amendment right of people to bear arms. They said the criminals have guns, and so should we. Well, the point of the matter is that when you get into an historical review of what the Second Amendment really means and how it was intended to be applied, you see that there's a whole lot of holes in some of the arguments about gun control. Not about gun control, about citizens' rights to carry guns and so forth. But nevertheless, be aware that the most powerful lobbying group, one of them, the National Rifle Association, has influence on Congress, and Congress passes laws and allows laws to take place about guns to control to a point. But there's a whole lot of issues that need to be worked on as far as guns. And I oftentimes hear people say, well, guns don't kill people, people kill people. Well, people with guns shoot people. I haven't seen an animal with a gun shoot anybody yet. But anyway, the fact of the matter is that there's a whole debate about that. In the attempt by jurisdictions, and this happened in Chicago as well as District of Columbia, held that handguns are unconstitutional under the Second Amendment. And the argument there was that Second Amendment never anticipated handguns. It had nothing to do with handguns. Heller had applied for a handgun for private use and was denied his request by the Federal Judicial Center, which cited the strict gun control ordinances of the district. Anyway, so the under the Second Amendment, as applied by the United States Supreme Court, they said citizens had a right to have guns and so forth. Again, remember what I told you? It is the courts who determine what the law is, even if the legislature passes it. Some examples involve the Brady Act, in which goes back to former press Secretary of Reagan, who was shot by John Hinckley, and Hinckley is in the head, and he remained paralyzed, and he passed away some years ago. Well, Hinckley had a criminal record, and so the Brady Act came about and said background checks should be given before purchasing a gun. Now, there were opponents even of that. They argued that it's unconstitutional because its provisions requiring local enforcement officers to conduct background checks was a violation of the 10th Amendment. The Supreme Court agreed but upheld the statute overall. The point of the matter is that, come on, people. You're going to tell me you're just going to let people just get guns without background checks? No. I mean, even with background checks now, people are getting guns. There are people who are getting guns who are unstable, as demonstrated by what happened in Fort Lauderdale. You know about that because it's big news now about this young man who was a former military person and got out, and he indicated he had some problems. He sought out psychiatric help, and then They took his gun away. He went to the FBI delusionally about things, just a whole bunch of things, and he was given his gun back. And he legally had his gun at the airport because he was able to pack his gun in the bag, and then when he retrieved his luggage, get his gun, and then you know what happened. There's some problems here. There's some problems here we have here. I don't care if you're an NRA member or not. I got this news for you, and here's the bulletin. Of those people who were shot and killed, if any of them were NRA people, I guarantee you their family members' positions would change somewhat to a point to understand a little bit more. And it's the sad part about it is that in the urban areas, gun control is really, really, really a big issue, like in Chicago, Detroit, major urban cities. But in the suburban communities, it's not as much of an issue. The point of the matter is that wherever you find a high, and then people say, oh, it's criminals that are using these guns. The fact of the matter is that oftentimes you will find there may be criminals using it, but they're guns that were legally obtained first. That's one of the issues. So anyway, that Second Amendment issue is a hot topic. The void of vagueness, the Fifth Amendment says no person shall be deprived of life, liberty, or property without due process. In other words, you have a hearing, an opportunity to respond. No statute or law should be vague. People should know what they're doing wrong clearly, nor should the law be overbroad so that it potentially can adversely affect First Amendment rights. Let me give you an example here. In the Coates versus City of Cincinnati, the United States Supreme Court, in an ordinance that was unconstitutional, saying it's a crime for 3 or more persons to gather together on the sidewalk, and that it says, and here's what the language says, and they conduct themselves in a manner annoying to persons, annoying to persons, annoying to persons. That should send up a red flag, that language, annoying to persons. The court said that the law was vague and overly broad because men of average intelligence would have to guess at what this really means. Not only that, annoying is a relative term. So what can annoy one person might not annoy another person. But the bottom line is that here's the deal. What they were trying to do, and we had the same thing here in Chicago in this next slide here. I know it's not this one. Maybe it comes up a little later. But anyway, maybe it's in one of my other classes. But there was an attempt at controlling gangs on the corners gathering. Well, the court said the same thing. They said you can't use. They're not doing anything. They're just standing there, and so you can't use that. You're violating the First Amendment rights of a person. Freedom from self-incrimination. No person shall be compelled to testify in a criminal trial against themselves. You don't have to take a stand. I've had many clients when I was a defense attorney that didn't take the stand for strategic reasons. And you have a right to remain silent. Of course, you know that through the Miranda rights as well. But it limits the degree to which legislators can write statutes that require persons to report information to the government that can place them in jeopardy of criminal prosecution. So in other words, if a law is passed that puts that person in jeopardy of criminal prosecution, then that's going to probably be not such a good law. Here's an example of what I'm talking about. Timothy Leary. Timothy Leary was we used to call him the drug doctor. This was in the 60s. And he dealt with marijuana and LSD and purple haze and all other kind of drugs. Anyway, the Supreme Court reversed the conviction of Leary because it was what they call the Marijuana Tax Act. And the Marijuana Tax Act required Leary to identify himself as a criminal since he was in possession of marijuana that was unlawful at that time in every state. So in other words, he had to report, the law said that he had to report that he was in possession of marijuana. Well, that law would fall on its face because of the fact that he didn't have to pay taxes on it, because of the fact that you would have to know about it in order for him. So you couldn't use the Marijuana Tax Act. So that law was illegal in itself. The sole purpose was to get you for tax evasion for not saying that I am a drug dealer. Okay. Can't do that. The prohibition against cruel and unusual punishment, the Eighth Amendment, applies to procedural as well as substance law. And as I talked about earlier, it generally applies to the death penalty. But it can be used to strike down crimes for status. For example, in Rasmussen versus California, the court struck down a law that made it a crime to be addicted to narcotics. In other words, if a person is addicted to narcotics, they could not be arrested for being addicted to narcotics. That's an illness. However, we'll talk about in a few minutes the however. But also that the death penalty, maybe I skip. No, we didn't. There's one I'm looking for, and I think it's after this. No, it's not in here. I teach so many classes. Be aware, though, that a person can be, back to that issue of Robinson, a person can be prosecuted for being drunk and disorderly, but they could not be prosecuted for being an alcoholic. That's status, okay? Death penalty cases. It is well settled since 2005 in the Roper versus Simons case that we don't execute juveniles. Scalia, who's now passed on, and Thomas, who's not one of my favorite justices, Clarence Thomas, argued that the court shouldn't legislate from the bench. And what they were saying is that the court was writing a law from the bench. But anyway, the point of the matter is that it's well settled, well, at this point it is, that we don't execute juvenile offenders. Before that, even, states could decide that they didn't. I had a young man I represented in about near the end of my career. I retired in 2000, but I started winding down in like 97, 96. I had a young man I represented. This young man was actually 95. He was 17 when he committed a heinous crime, and I negotiated a plea for him, but he didn't accept it and went to trial. But the key thing was by the time he was tried, he was 18, and he could have been executed if he was 18 when he committed the offense. But because he was 17, he was considered a juvenile, and he ended up spending natural life in prison. So that was in Illinois. But what Roper did was make it uniform across the United States. That is a violation of the Eighth Amendment. Cruel and unusual punishment. Privacy. The government, in terms of dealing with the Ninth Amendment, shouldn't interfere in the privacy of the lives of people, such as the intimate personal conduct. And in the Ninth Amendment, the enumeration of certain rights not construed to deny or disparage rights retained. The Griswold case has nothing to do with Clark Griswold. Those of you who may be laughing, Clark Griswold, as you know, was Chevy Chase in those series of vacation movies. But there was actually a case called Griswold versus Connecticut, and it had to do with we call it the famous contraceptive case. And it is right here, in which the Supreme Court struck down the Connecticut birth control laws, saying that it violated the constitutional privacy of marital people who were married. Estelle Griswold was convicted for aiding and abetting persons. And so what she was doing was counseling people in using contraceptives. And they said, oh, that's a violation of the law. Well, no, that's the right of those people to decide that these were adults and they were married. They were married. marital privacy. Now, notice this. This was the Griswold case in 65. Then later on came this next case, which is in 72, which applied Griswold to unmarried persons as well. So that the same thing that applied back in 65 then extended in 72 to unmarried people as well. In other words, who's going to go in, bust in your bedroom and stuff like that? No, we don't do that kind of stuff. Abortion, there's a whole debate about abortion. We're not going to spend a lot of time about it, but pro-life versus pro-choice, that's more of a constitutional issue, but it is something that has to do with our Constitution. And then finally in Roe versus Wade, abortion was allowed, but there were certain standards that were laid out for it as well. And then there were pro-choice and pro-life people. Okay. Then you should know that prior to 60, government determined a lot of sexual morals. But then after Roe versus Wade and Griswold, rights to privacy increased, and then provided the prerequisite for gay, lesbian, and the BLGT movement that is presently with us now. This was the initiation of that, so the people's private sex lives should not be intervened into by the government. And then this was applied to LGBT in 2003, said that people had a right to privacy regardless of their sexual preference. Okay. The right to die issue, there's a whole issue about that. We're not going to spend a lot of time on that. Medical treatment, people can determine that issue, and there's a debate about that, saying that the individual needs protection because of the fact that they're not in a state where they can determine whether they should live or die. There's a whole section that takes place in one of my classes where we talk about the right to die in terms of doctor death. People like a guy that existed years ago, Dr. Kevorkian, who took the lives of people who were very terminally ill, and you've seen cases like that. Equal protection law applies equally to everybody, and then these are some of the cases. Now, this is probably one of the most interesting things. You'll be surprised. There was a movie, and there's a movie out right now that involves this last one, Loving versus Virginia, which I always thought was very interesting. It was in 1967 that I was 17, and I went to school. You know, there were people of all races. People were falling in love with each other, different races and nationalities and so forth. And ultimately, some of those people would later on end up getting married. But it was not until 1967 that the Supreme Court in Virginia still had on its books to restrict a person from marrying a person of another race. The state of Virginia convicted them because they were different races. At the time, Virginia had a law forbidding interracial marriage. The court said, that's enough of this. This violates the Equal Protection Clause, and that people have a right to marry whomever they want or whatever race. It's interesting. And this was even after Jim Crow. This was even after the Civil Rights Act of 1964, that some jurisdictions still would enforce those kinds of things. And it continued on until 67. But there's a movie about that now that's out. I forgot the name of it, but a couple of my students brought it to my attention. We already talked about judicial review. The courts have a right to review cases, but there are different tests they use. They use these three, the courts. The judicial requirement that legislation or the law must be rationally related to a legitimate government objective. Must be something that the government is trying to protect. That's the rational basis that to determine if it is determined that is rationally related to a legitimate government objective, such as to protect the public or something along those lines, then that law will stand. Strict scrutiny applies to First Amendment rights, so which says that there's a heavier burden. You're going to have to really, really, really come up in terms of justifying why you are this law should stand, and it's one of the toughest. The compelling government interest standard requires the government to prove that its interest is strong enough to override a fundamental right. It doesn't happen very often, but the fact of the matter is that in this instance, the government must prove that the government interest is strong enough to override a fundamental right. Some have argued that the Patriot Act is unconstitutional, but it is probably, if you apply the rational basis test, you might find that the law stands or the compelling governmental interest. But I would tend to go with the rational basis test. But these are tests that apply to law. So if it's a First Amendment right, it won't fall under any of these. This is the court and how they'll look at it. It's a kind of a complicated concept, but I'm just explaining to you that there are different tests used to look at different kinds of laws and how they might affect your constitutional rights. State constitutions are based on what the states say they are. However, they cannot conflict with the federal government. And that's it for that. Okay, so it's 9:40. We got about 20 minutes left. So we're going to do Chapter 4. Does either of you have any questions about Chapter 3, or is it pretty clear? Any questions, Eric or Teresa? Teresa, none. Eric? No? Okay, great. All right, so let's go through 4, and when we get to 10 o'clock, wherever we are, we will stop at that particular point. The elements of crimes and parties to crimes. Let's go back. We skipped over a couple. Okay. The way crime is set up is that there's things called the elements of a crime, the act of it, or as a wrongful act, and then the intent. It's called mens rea. Mens rea has to do with the criminal intent, the state of mind. There was a movie that one of my favorite ones called Legally Blonde, where Elle Wood starts telling the judge about mens rea. Well, mens rea, very simply, all it says is that there must be some intent implied in the act that's done. When we get down to that, the prosecutor has to prove either commission of an unlawful act or the omission of an act. Now, when we get to strict liability crimes, most time public welfare offenses, we're discussing that this week in our discussion forum about the driver's license issue, but then there are some students who brought into the mix what do they call those? The individuals are charged with statutory rape in those kind of situations. Well, the argument, some say, well, the person didn't really know, or the person misrepresented. And strict liability crimes go with, like, for example, this person driving this car, he didn't know that his license was suspended, was driving. The law says, so what? You are guilty by committing the act. All the prosecution has to prove is that the act was committed, such as driving on a suspended license, such as the evidence established that the individual was, in fact, a minor that you had sex with, whether or not you knew or not. And so it's strict liability. And so it applies to public welfare offenses. And so how is statutory rape? It's a good public welfare offense because we're protecting minors. Minors don't have the right to give consent. They can't even sign contracts and those kinds of things. And so as a result, the law steps up and protects these individuals and protects us. I didn't know that this law was on the books. It doesn't matter. If it's on the books, and you violated it, you're guilty under strict liability crimes. No mens rea is required. No criminal intent. In other words, you don't have to intend, just the commission of the act. Felonies and misdemeanors. Now, I'm going to ask you, what's the difference between a felony and a misdemeanor? Either of you. Can you type that? What's the difference in a felony and a misdemeanor? And where can you determine whether an act is a felony or a misdemeanor? Felony is a criminal act, so is a misdemeanor. So what's the difference? They both are infractions. How do you know whether it's a felony or a misdemeanor? Anything further? Misdemeanor is less serious. Okay. All right. Now, misdemeanor is less serious. How do you know that? You're on the right path, but how do you know that? There's one thing that tells you the difference between a felony and a misdemeanor. You're on the right path. What is it? How do you know that something is a misdemeanor? No, they're both defined by law. How about this? How about the sentence? How about the sentence? The sentence tells you whether or not a crime is the potential sentence. The dividing line, no. The dividing line is this. If a person is sentenced to up to a year, it's a misdemeanor and or a fine. If a person is sentenced a year or above and or fine, it's a felony. So the idea is that the dividing line is the sentence. The sentence is what determines whether or not something is a felony or a misdemeanor. Speeding and driving a car could be a misdemeanor unless that speeding was excessive enough and causes death or serious bodily injury. Then it becomes reckless and it's more serious, and then it can become a felony. If you, for example, commit a battery, and a battery is an unlawful touching, an unwanted touching of a person, hitting, striking, that is a misdemeanor. But if you use a weapon, a bat, a stick, or something, then it becomes what we call aggravated battery, and it could cause more serious injury, and it's likely to become a felony. So never forget that. The difference between a felony is that a felony is the amount of time you could potentially get for a crime, a year and above. A misdemeanor could be under a year and or a fine. You could have a fine with both of them. But the key thing is the amount of time that you go. Most of the time when you're convicted of a misdemeanor, you don't go to prison. You go to jail and you serve your time. But if you commit a felony, you could, if you don't get probation, then you could end up going to prison because it's for a longer period of time. That's it. That's it. Never forget that. Never, because you'll be asked that again and again and again and again. But if you start to think of it on the basis of the sentence, that's the answer right there. Okay. All right. Actus reus, we talked about that, which is the act of the criminal. Willfully committing an act, such as robbery. Robbery. What's the difference, if you know, between robbery and theft? Do you know the difference between robbery and theft? Robbery is used with a weapon. Yeah, you're on the right path. Actually, here's the difference. Robbery is taking it from the person with the possibility of force using a weapon or threat of bodily harm. Theft is just taking something. You're going to need to know that later on in this course. You'll see later on in one of your discussion posts. I think it comes up in this class. I'm sure it does. I know it's in one of my classes. I think it's in this one. But robbery, a physical act. Intentionally fail to act when the law requires a person to act, negligence or failure to provide medical treatment. That could be actus reus. So it could be omission as well as commission of an act. Possession can be a wrongful act, such as carrying a concealed weapon, unless you have a concealed permit. Possession of illegal drugs. Actual possession is where it's in your immediate control. Constructive possession is the power and intention to control something either directly or through another person. So here's the deal. You're in a car, and you're the driver, and they find open alcohol in the car. Are you in actual possession of that alcohol? I mean, assuming that someone's in the back seat is drinking it open. Are you in actual possession if you're the driver? Maybe, maybe not. But it doesn't matter because the driver is going to be held responsible under constructive possession. The power and intention to control something either directly or through another person. So you can be held responsible. Now, some people have, well, you can still be charged, not as an accessory, with open bottle in the car. You're actually going to be found guilty of operating a vehicle with open alcohol. That's not an accessory. But the fact of the matter is that you can be as accountable in a situation like that, whether you knew or not. You should have known in that situation. Now, here's the other thing I want to point out to you, is that let's say, for example, a person's in the car and they have some drugs on them, and then, you know, they just have it in their pocket and they're arrested, and you're the driver of the car. Probably you are not going to be held responsible for that because you don't have the necessary right to pat down everybody in your car and those kinds of things, okay? But if it's found on the seat of the car, you could possibly be charged with possession under constructive, possibly. Listen to me good. The law operates where it doesn't necessarily mean that the charges are correct. That's why you have a right to defend against them. And I have represented people who involved in crimes. For example, I'll give you an example. I had a young man I represented one time who was dead drunk in the back seat of the car. He was so drunk he was knocked out. But the passenger, some other passengers and the driver, they went into this house and they burglarized the house. And the police got them all in the car. And he was arrested too. However, I became his attorney. I got him acquitted because I was able to establish that he had so much alcohol in his system at the time that he could not have possibly been one of those who went in, nor could he have participated in it because he was knocked out. So he got away. Cost him about $8,000 to $9,000, almost $10,000. His mom had to pay me to represent him. He was found not guilty. But the point of the matter is that he was charged like they were with burglary, but he was found not guilty because I was able to prove that. Okay, good for you. That's funny. All right. I like that in you. Yeah, okay. You must be getting ready to be a police officer, Teresa. All right. And they probably know that, too, about you. No, so. All righty. Oh, you did corrections. Okay. Okay. Well, same thing. That means that you got caught and you're in. So the bottom line is you still believe in following the law. So, all right. Now, here's the thing about status, and I was talking about this a little earlier. Amen. Status involves a condition, such as, for example, or a situation, public intoxication. Now, the Supreme Court struck down a California law that made it a crime to be addicted to narcotics. I talked about that a little earlier. The Supreme Court upheld a law making it a crime to be in a public place while intoxicated because it's a status. Now, let's move a little further. In Rasmussen versus California, we talked about that a minute ago, California implemented a new statute that made it a misdemeanor to be addicted to narcotics. To be addicted to narcotics. The Supreme Court said, no way, that's a violation of the 8th Amendment, and the 14th Amendment is applied to the states. The justices said that the new statute was cruel and unusual punishment, which it would be, and said that you don't punish people just for having a cold because he was addicted to narcotics, okay? And because he was, didn't say he was in possession of it, he was addicted to it, and so as a result, you can't prosecute a person for that. That's their status, okay? Just like having a cold is a status as well. They're both illnesses, so you can't prosecute them for that, and that's what that was about. The Supreme Court upheld the conviction, though, of a person for public intoxication. Now, this is different. This person was a chronic alcoholic, which was a sickness, okay, and argued that it was cruel and unusual punishment to be convicted for being a chronic alcoholic. Well, the Supreme Court, with Justice Thurgood Marshall, said Powell was not being punished for being alcoholic, but for being in a public place while intoxicated. It's a difference. It's a big difference. He was actually intoxicated in the public place, which put it beyond his status. He was actually disorderly in a situation like that. That's what that was. That's the difference. So in other words, you can't prosecute a person under Robinson for status, but you can prosecute under Powell for a person being intoxicated in a public place. Big difference. We already talked about mens rea, the criminal intent or mind, except with strict liability. Mens rea is not the motive of the crime. All the prosecution must prove is the criminal intent, but not necessarily a motive, not why you did it, but that you did it. And so it is inferred from the actions that you either knew or should have known. A motive is a reason why a person commits an act, okay? Acts can be simultaneously, but not necessary, okay? Mens rea, has been weakened because more and more we're getting closer to the time where nonviolent offenses are more and more heading towards strict liability. These crimes, the prosecutor just must not prove mens rea, but just that the person committed the act. So basically, there's some argument in civil liberties saying that no, you're doing away with the mens rea. That's a protection constitutionally for the individual, but that's a whole debate. Specific versus general intent, we talked about that. Willfully and unlawfully, that's general intent. Specific intent involves the mental purpose to accomplish a particular act prohibited by law. For example, to willfully with intent to injure a person. Okay. A specific intent statute defines criminal conduct in which the defendant must harbor a specific intent. For example, taking a vehicle to cause a person's death, such as running over a person or speeding or driving under influence, something like that, okay? Constructive intent, though, on the other hand, involves a substantial likelihood of an event occurring even if there was no specific intent, such as probably speeding as well. Okay, we're not going to get into this too much, but Congress has adopted the model penal, but the U.S. Supreme Court doesn't really follow it so much. The law of intent is kind of like pushed to the wayside, but that most statutes you will discover have this language in it. This is where it comes back to. Intentionally, knowingly, recklessly, criminal negligence. You'll see these elements expressed in the statutes as you look at the statutes in almost every municipality. Transferred intent, where you intend, for example, to do one thing, but it results in something else, such as shooting at one person and then missing them and hitting someone else. It also applies to arson. Like, for example, well, let's say, for example, you didn't intend to burn the place down, or either you didn't intend to kill a person, but it's transferred intent. Most of the cases involve homicide, where, for example, the offender missed the target but shot or injured a third person. That's what we call transferred intent. Kind of gets to what we call felony murder, which I won't go into that right now because you'll be talking about that. We'll be talking about that later on. Strict liability, we've already talked enough about strict liability offenses. And then here's a chart. I'm going to skip over that. This person was convicted of stealing spent bomb casings that was left on some land that was uninhibited, which military had labeled as a bombing range. In his trial, the court had disallowed him to argue that he did not intend to steal the casings and took them because he believed they were abandoned. The Supreme Court overruled his conviction, saying that the trial court erred in removing the element of intent because he wasn't intending on stealing them. He just found the items, and so they were trying to say, yeah, but you should have known that there used to be a military range here, therefore, no. The court says, no, not adequate, it had been abandoned. Strict liability, okay, we're going to skip over that. Causation. We call this kind of goes into tortious issue, or torts, or accidental. Causation means that there is a linkage between the cause and effect. For example, we're almost done here. It's about 10:02, but we're going to wrap up in a minute here. The gunshot caused the death of a person. So the proximate cause of the death of that person is the gunshot. If the gun shot hadn't taken place, the person would not have died. That's the causation. I mean, there's a between the cause and effect of their death. Also called proximate cause, as a cause that in natural continuous sequence, unbroken by an intervening cause, produces the consequences that occur. If there is an intervening cause, punishment will likely be different. Let me give you an example right here. Here's an example right here that brings it right clear. In this case, this woman is raped, and she's left to die in an uninhabited area by John. She manages to crawl to the next street, and a truck driver picks her up and intends to drive her to the hospital. The truck driver, however, causes an accident in which Emma dies. So the question is, does this is this death attributed to John because the whole thing was triggered by him raping her? Do you think that's true? You think John is held responsible for her death? You do. The answer is no. No. Because John's actions had nothing to do with her death. He would be responsible for rape. The accident is not related to the incident for why she was in the accident. There's an intervening cause. The intervening cause was the truck driver picked her up and was either negligent or somehow ended up in an accident and she died. So John should be charged with rape, but not her death. Now, under the causation requirement, because the cause of her death was the accident, not her rape. Now you get it? See, some people might think, okay, well, if John hadn't raped her, this man might not have picked her up. Yeah, but the chain was broken. It was broken. It was broken because it's not even closely related to what John did. All right. So anyway, that's how that applies there. Okay. Parties to a crime. The principals, those directly participate, accomplices, those who aid and comfort, principals. That's all I'm going to say. I'm not going to get into the details of this. Okay, we're almost done here. Accessories before the fact. One who procured, and we talked about this earlier, or counseled another to commit a felony. That's a before the fact. Person was not actually or constructively present at the crime, but they counseled or procured counseling another to commit a felony. That's like, for example, if I provide you with a gun and you go out and shoot somebody. That's an accessory before the fact. Accessory after the fact is after the fact. Remember, before, after. One who with knowledge of that person's guilt attempts to hide that person or prevent them from being punished or arrested. The modern approach abolished both substantive and procedural distinctions between principles and accessories before the fact. The modern law defines a principle. This is a principle now, so it doesn't matter whether you were before the fact or either during the fact. The modern law defines principle as all persons concerned in the commission of a crime, whether it's a felony or misdemeanor, and whether they directly commit the act, constituting offense, or aid and abet in its commission, or not being present have advised and encouraged its commission. So basically, you could be, even if you're not there, you could still be as culpable as the person who did the act itself. Of course, accessories after the fact still exist. Okay, and that is the end of our session for tonight. Do you have any questions? Okay, Eric, okay. All right, so the key idea that I try to do with each of these lectures, as you can see, is try to elaborate on some of the things that you will look at and you will read, and by asking questions and by giving you examples of how things operate, because just reading some of this stuff alone, that's like some of the things that you thought that meant what it says. No, it didn't necessarily mean that. So that's my goal and objective. So again, our next lecture will be 2 weeks from today, in week 4. I tell students all the time, we have 5 lectures after the open house. Now we just got 4 more to go. I mean, just think about it. You're almost, 4 more to go. That'll be week 4, week 6, week 8, and then finally week 10. It goes pretty fast. So that's about it. I'm going to send out an archive to everyone of this lecture, and I'm going to say good night to everybody. Okay, good night.